Afternoon, I'm Julie Bann. I'm an employment partner here at Sharpe Pritchard, and I'm going to be starting the talk today on top tips on conducting an investigation in an internal perspective. We're looking predominantly investigations in relation to employees, and I'm joined today by my colleague Charlotte Smith, who's a data law expert. I think Charlotte's just going to introduce herself.
Yeah, hi there. My name's Charlotte Smith and I'm a solicitor in our technology and data team. And I'm going to be talking a little bit about some of the data protection aspects that you need to think about when doing an internal investigation.
Thank you. Thank you, Charlotte. So if what we'll do, because of the format, if you've got any questions as we go through, if you can type them into the chat box, the Q&A box, we will pick up on all those at the end. If there's anything that we don't cover, please also raise that, and it may be if we haven't got enough time, we will organise another webinar at a later date. So we're going to move swiftly on and start the process. The investigation is the cornerstone of any fair process that you do in employment law. So when you're looking at unfair dismissal, for any of the potential fair reasons, you're looking at do you have a fair reason for dismissal, and have you followed a fair process in reaching the decision to dismiss? So there's two questions there really. Did the employer follow a fair procedure, and did you act reasonably in treating that as a sufficient reason for dismissal? Also, you're also looking at the ACAS Code of Practice for disciplinary and grievances, and the cornerstone of that process, the first stage, is follow a reasonable investigation. And when we talk about disciplinary here, we're looking at also in terms of capability processes, in terms of sickness management process. They all start with a fair process. I've added there a little tip in terms of right to be accompanied. There is no legal right to be accompanied at the investigation stage, but please check your own policy, because it may be that in your own policy you do give that right. You need to consider be flexible on this, depending on the seriousness of the allegations and also the individual concerned. There may be good reasons why you do bend that right. If we can move on to the next slide, Charlotte, if that's all right, please. So first top tips, first, act promptly. You wouldn't believe how many cases we see where examples of poor conduct or performance are not dealt with at the time they arise, either because the manager then doesn't like the difficult conversation, or because of timing, or because on its own that specific issue doesn't seem to be enough to instigate an investigation. But the purpose of having a process where you have an informal and a formal stage is to nip those first examples of poor conduct or performance or sickness absences in the bud, and raise them promptly. Even employees, in terms of their grievances, have a duty to raise them promptly, and that also goes for your own investigations. Secondly, it's absolutely vital that you keep and maintain records. So even informal processes, informal conversations, you should keep a record of the conversation and confirm it in an email, so you have a paper trail that it actually took place. All formal meetings should be minuted, and the minutes should be kept somewhere where you can find them. I've had a number of cases where a process has taken a period of time, and those initial conversations or those initial meetings have been minuted, but just in a handwritten form in the notebook of that particular manager, and they can't find them when you need them, when it comes to either the final stage or, if the worst happens, to a tribunal hearing. So maintaining records is vital, and communicate with the employee regularly throughout the course of the investigation, because one of the key things that people raise in employment tribunal claims is that that I didn't know what was going on, that no one kept me updated. So it's really important that you do communicate with the employee regularly, because up until the point that they're not your employee, you have to treat them with a measure of fairness and respect. Charlotte, can you ping me on to the next slide, please?
There we go.
There you go.
Sorry.
Right. When we start the process, you have to consider who is the right person to be the investigator. Now, it may well say in your own policy, your capability policy or your disciplinary policy, what level of management has to deal with each particular stage of a process. So you have to follow your own policy if it does say that. Now, quite often you'll have a situation where it makes sense that the line manager is the person that investigates the specific issue. But often this causes disputes because the line manager may have built a relationship, a good or bad, with the individual, and that can form a bias within the investigation, which means that you get the allegations that the process has been flawed. So consider, and I know in a variety of public sector organisations, that the policy will say that somebody not within the supervision chain conducts the investigation, and I think that's a really good way of handling it. I think it's really important to consider whether your managers need training to undertake investigations, because it's not quite as simple as just having some meetings in it. And it's really, as I say, because it forms a cornerstone of all fair processes, this is the bit that has to be done absolutely fairly and reasonably. I would also consider, if you're looking at an investigator, does the person doing the investigation have to have specialist knowledge? So it may be, if you are investigating something within the finance team, having knowledge of the financial processes is important. It may be a safeguarding issue, so somebody who has knowledge of what it actually means to breach safeguarding regulations, for example, would be appropriate. So consider that carefully. If you could ping me on, Charlotte.
There we go.
There you go. So the next tip, because the investigation is so important when you're looking at how you've conducted yourself as an employer, and because you want to be seen to be a fair and reasonable employer, I think it's a really good idea to give some terms of reference for the person that's conducting the investigation in writing, to show that when you started the investigation, you did so on fair grounds and you gave your investigator full remit to make to gather the information that they required and make whatever decision they considered was appropriate in the circumstances. So it may be that you want to say to your investigator, these are the allegations that are against this individual. For example, we've got CCTV footage of this employee punching another employee in the middle of the office space. So we have that, but we do not want to prejudge the situation. We want you to follow all the evidence and be open to the right outcome. And we can say that, as far as we're concerned, there are three possible outcomes to the investigation. You may find that what was seen on the CCTV footage was not what we've all presumed, as in an act of violence, and you may drop the matter with no case to answer. You may consider in the circumstances it's not as serious as a formal disciplinary process and consider that an informal outcome was appropriate, or you may consider disciplinary hearing is recommended. We do not have any specific outcome anticipated, and we give you full remit to take whatever decisions you consider necessary. And I think it just sets your investigation up on the right footing. If you can wing me over, Charlotte, please, if you can. Right, so from the investigator's perspective, their role is to gather the facts. And so the first stage is usually to arrange a meeting with the employee and provide them beforehand with any evidence that's already been collated, so they have an opportunity to consider the evidence and how they would react to the evidence. Asking open questions is really important, because a lot of investigations start with the allegations, and the investigator investigator then goes into the process trying to prove that those allegations, so asks leading questions to get the answers that they're hoping to find. Take a record of the meeting. By that I mean a good minute of the meeting, and agree the minute of the meeting with the employee. If possible, take a note taker, because it's very difficult to take a note and listen effectively. Discuss with the individual any potential witnesses that they consider or would be helpful to speak to, and consider the physical evidence. So if there is CCTV footage, the investigator needs to be showing that to the employee at the time and taking their comments at the time. So all evidence should be before all parties, and a note taken that they've actually viewed that footage. You can wing me on, Charlotte, please. So on recording and communication, I'm not going to cover data subject or data protection issues, because Charlotte will cover that shortly. One of the questions that often comes up for investigations is, should you allow the meeting to be recorded, or should you record it yourself? Now, I find that the difficulty with recording a meeting is, if you rely on that as your minutes of the meeting, if something fails with the recording, or you can't hear very accurately, it just creates a further dispute. Secondly, if the meeting is, say, 2 hours long and you've got a recording of it, you're still going to have to transcribe that recording into minutes, and your minutes are going to be 20 pages long rather than a summary of the key issues which you would ordinarily expect in a minute of a meeting. So you're only adding a further stage to creating the minutes anyway. I wouldn't allow the meeting to be recorded by the employee ordinarily, because they then hold that information, and you know, if for whatever reason the individual is dismissed, you may not get access to that at a time that you can actually consider it carefully and determine if it's a full recording of the meeting, or they've cut and pasted it to suit their own agenda. I would suggest that at the beginning of the meeting, depending on what your decision is on recording, that you confirm, and it is minuted, that what the parties agree. So it will be recorded and who's recording it, or it will not be recorded and all parties agree that they're not recording it. And I would make sure that, as I say, that is minuted, because we get in a lot of situations where there's been covert recordings, and tribunals do allow them in. But if you're not aware of it at the time when it's going on, you know, investigators, everybody has informal conversations during the course of these meetings, and they may not necessarily say the same things if they knew that they were being recorded. So I think it's important for everybody to be on the same page. Can you wing me on, please, Charlotte? So moving on to witness evidence, you've got a situation where you've spoken to the individual who you're investigating. So if it's performance, if it's disciplinary, if it's grievance, you've spoken to the person that's raised the grievance and you've taken further evidence. Then you're looking at who are the witnesses. Now, what I would say is really important is that as an investigator, you actually meet with the witnesses and to take their statements. And at the moment, it may be a virtual meeting, but what you shouldn't do is just say to the witnesses, we have received these allegations, you are a witness, please just send me your version of events, because the witness is going to give their version of events, not necessarily in the context you need, and not necessarily with all the information you need, and you can't just rely on that. There may be further questions that arise as a result of that, so it's better to have an interview. It should be minuted and it should be agreed with the witnesses and followed up with any additional interviews if information comes through to light that the investigator wasn't aware of beforehand. Can you ping me on, Charlotte, please? Okay, so it may be, depending on the issues, that you have reluctant witnesses, so people that do not want to put their name to their statement. Now, the ACAS guide states that if at all possible, you should try and avoid anonymising witness statements, because the employee under investigation will be disadvantaged because they won't be able to effectively challenge the evidence against them if they don't know who's created the evidence. So it may be that there is a witness that gives evidence that they actually witnessed something, and the employee may say, well, they couldn't have witnessed it because they're at the other side of the room and there were several people between us. So you've got to balance the rights to have a fair and reasonable investigation and the rights to be able to respond to any evidence against the witness's right to not put their name on record. What we'd say is, don't ever start the process and offer anonymity, except where you're already aware that there are exceptional circumstances where it is required. And I would say that when you start any witness, when the investigator starts any witness meetings, you should make it clear that you're taking a statement, and that statement is going to be made available to the individual concerned. If the witness raises the fact that they don't want to give evidence, or they're worried about giving evidence and putting their name forward, then you've got to consider carefully their motives for the reluctance to give a statement on record. If there are legitimate fears for their safety and the investigator is satisfied that those fears are legitimate for whatever reason, then the statement can be anonymised. But it's got to be clear to the witness that even by anonymising this statement, the individual may still be able to identify them by the very nature of the content of the statement. So there's a lot of factors to take into account in that case. And as you can see, I've just quoted a case, a View Entertainment case, where the EAT said there's no universal rule that full disclosure is always required. You've got to look at it on a case-by-case basis, depending on what the charges are and the strength of balancing or the different considerations that justify non-disclosure. What I would say is take full notes initially and then redact if necessary. Can you ping me on, Charlotte, please? Okay, so it's really important to remember that the obligation to investigate and review the evidence is ongoing. It doesn't stop at the investigation stage. So the investigator has gathered the facts, has presented the investigation, shouldn't give an indication of what outcome they expect. Their purpose is to gather the facts. That's their purpose. And then if it's going forward to a disciplinary or a formal performance management hearing, then the disciplinary manager will be appointed, and then at the third stage an appeal manager appointed, and they have a continuing duty to review the evidence and, if necessary, to reopen an investigation or to consider further evidence as it arises. And as you can see in the Udin case, the EAT pointed out that the knowledge or conduct of a person other than the person who actually decided to dismiss could be relevant to the fairness of the dismissal. So there could be information, in this case, the information that was in the mind of the investigator that they didn't pass on to the disciplinary manager for whatever reason. It could be ulterior motives. But the disciplinary manager still has a duty to consider all factors, and if there's any element where they are concerned about the investigation, then they should go back to the starting point and review that. Can you ping me on, please, Charlotte? Right, I have finished my section. I'm going to pass you on to Charlotte now to cover data protection angles for an investigation. Thank you.
Thanks, Julie. I'm going to talk about a bit more about data protection. And the reason it's important in the context of investigations here is because of the type of data that you're dealing with. So, HR data is going to include sensitive data about individuals. So that could be financial information. You've got all the payroll data about an individual and tax information. and also what the GDPR calls special categories of data. So that's things like health data, trade union membership, it could be equalities data that you collect about people, all of that type of information, and that could form part of the investigation, depending on whether it's relevant. There's also going to be potentially a large volume of data that is collected, and you'll be using that data to make decisions about employees. So, again, that's why it's really important. It's about what are you actually using that data for, how are you processing it, and why. There's also the issue of a potential, or perceived at least, imbalance of power between employer and employee. So that's why in the world of data protection, it's often difficult to rely on things like consent as a reason for processing, because it's difficult for you to prove that consent is ever freely given if it's an employer asking an employee for that consent, because there's always an argument the employee is going to feel like they have to consent to things. So you have to be careful about how you're using the personal data and make sure you're only doing it within the remit of data protection law and the principles of the GDPR. Let's move to the next slide. I think I've still got the issues now. I can't move on to a slide. It's just so typical. Sorry about these tech issues that we've got. So the other thing to be aware of, just still talking about this side of the large volume of data, and I'm just going to talk about it in the next couple of slides, is that you need to think about how, there we go, you're determining your lawful basis for processing and ensuring that any employee monitoring that you're doing is in accordance with law. So under the GDPR, first of all, you've got the principles of data protection. So you've got to think about things like data minimization, limitation. So only process what you need for the investigation. Obviously, that's difficult because it might at first involve you having to sift through a lot of things to determine what is relevant and what isn't, but really try and narrow down exactly what it is that you need to hold for this investigation. You're not using anything more than you need to. And determine your lawful basis. So we touched upon that earlier. Consent might not be applicable here, so you need to think, what's our lawful basis? So most likely in a scenario like this, it's going to be legitimate interests. So that's where you as the controller have a legitimate interest in the processing. But in that context, you have to weigh it up against the rights and freedoms of the individual. So there needs to be a balance there. It needs to be proportionate. And therefore, in assessing that, I'd advise that you carry out a legitimate interest assessment. So it helps you think, what are my reasons for having this data versus how is that going to intrude on an individual? So it's really important to think about that from the outset. Also, familiarise yourself with your organisation's policies. So in terms of investigation and data protection, so it's not just about complying with the very strict letter of the law, but what do your organisations say about processing personal data, and therefore what's the employee's expectations of that, and in there that might give you some guidance about what your lawful basis is. And just thinking about the lawful basis point, just kind of preempting any questions, public bodies, it does say in the GDPR, can't rely on legitimate interests as a lawful basis, but that is only when you're carrying out your public tasks. So anything that you're doing in terms of actually, responsibilities of a local authority, that's what you're doing as part of your public task. But you don't, but anything else, if it's about like employees, so anything that any organisation would do, any business really, legitimate interest can be used there as your lawful basis. Other things whilst you're beginning the investigation is looking at your privacy notice. So hopefully you've got one for your employees, and that will set out how you look after all your employee data. It's a requirement of the GDPR to have this document. But have a look at that. Does it say anything specific in there about investigations and how you'll handle investigations? If not, it'd be worth doing so, or at least bringing the additional information to the attention of the employee who's being investigated. So you can say, right, this is the investigation, we're going to be doing this with your data, we may have to share it with an external person if necessary, and being really upfront and transparent about what you're doing. If you think there is any issue about the data that you're using, so maybe it is CCTV and you're a bit concerned about how that was captured, or is it because you're relying potentially on a recording that was recorded on someone else's device. So someone has used a mobile phone and recorded something from, you know, the corner of a room, and you're concerned about any privacy impacts, then you should be carrying out a data protection impact assessment and also engage your authority's data protection officer. So every public body has a data protection officer. That's a requirement of the GDPR. And that person is a person within your organisation who's trained on data protection matters, and they're there as a point of call for issues like this. So do engage them when you're facing tricky issues. And also at the beginning, you know, as we mentioned, take steps to mitigate what you're processing, be in line with those GDPR principles. So there we go, could actually move the slides this time, which is a good thing. So during the investigation, make sure you continue to comply with the principles. Don't just think, right, this is an exercise I'm doing at the beginning, never have to think about it ever again. Keep it up all the way through as you're discovering more evidence, as you're taking more witness statements. Keep considering about data minimization, never collect more than you need to. Keep considering how you process and you share witness data. So obviously we were talking about getting consent, but also think about how you're going to look after that. So if it is something that is particularly sensitive, although you might have decided whether, you know, there is consent or not for sharing that witness statement, or you've made the individual aware that it's going to be shared, only share it with who it is necessary to share with, you know, obviously. And it's a sensible precaution, but it's always worth reminding people, don't be passing things around that don't need to be seen by others. Keep everything under review. So are you still only processing what you envisaged at the start? Have more things come on board? So maybe at the beginning you thought, okay, this is all okay. It's quite simple. I know what data we're processing. It's nothing out of the ordinary. But maybe something does come in later on and you're a bit concerned about whether you should be holding that data or you shouldn't. Maybe at that point, it's the time to carry out a data protection impact assessment, or get on the phone to your DPO and ask the question. And then there's the tricky issue. I mean, we could do a whole separate webinar on subject access requests, so we're not going to go into loads of detail here. But with an investigation, there's always a possibility that you're going to get a subject access request in from the individual. So make sure you handle that in accordance with legislation and your own internal processes. So, you know, respond to it within a month, and have a look at what your authority says about subject access requests. I mean, local authorities are in a great position in that, you know, for years they've had FOI teams and always had data protection teams, and GDPR has caused an increase in subject access requests because I think there's just more knowledge of them now by individuals that the general public understands that it is their right to access personal data. So just because you might feel like someone's doing it potentially to be a bit of an inconvenience, you have to remember it is their right to do it, and there's only a few exclusions that you can rely on to not provide personal data. And also, you know, remember you'll have a data protection team there. So if you're the team handling the investigation, perhaps you're not best placed and best resourced to be managing a subject access request. So give it to the team in your authority that manages subject access requests and allow them, you know, to apply their knowledge and their expertise to manage that. And then it avoids there any issues about you being concerned of it impeding on the investigation. You know, just see it as that person has that right to that data, give it to the subject access request team and let them handle it from there. I mean, they may always come back and involve you and they're going to need information from you, but following the internal process, I think, will enable you to keep a bit of distance from that and just allow the subject access request to be carried out where necessary. So I'm just going to wrap up there. There's kind of just touching upon the data protection issues that you face in an internal investigation, a quick run through, but the main points of reference here is the GDPR, the General Data Protection Regulation. It is EU law, but it's going to be brought into force into the UK at the end of the transitional period. So it's going to continue in force, and I don't think there's any plans at the moment to massively change it. So it is going to continue to be in place. The Data Protection Act 2018, it's not separate from the GDPR, it needs to be read alongside of it. So in there's a lot of things that are actually related to employment. So There's additional conditions you have to meet for processing employment data. It's also where you're going to find any exemptions that there are to complying with subject access requests. But again, I'd leave that to your information governance team to handle. And also the ICO, so the Information Commissioner's Office, they're the regulator for data protection in the UK. They've got an employment practices code. Now, that code was written under the old law, under the 1998 Data Protection Act, but it's still relevant. The principles of it are still relevant. So if it refers to a section of the DPA 98, ignore that. But the general principles of that are quite relevant, and it links out to other advice that the ICO has around complaints data and things like that. So it is a useful resource if you're wondering how to handle employee personal data. So we will end the presentation there, and then let's see if we've got any questions in the Q&A. There we go. Oh, Julie, you're still on mute there.
Right. So I think the main question here is if a witness refuses to allow their minutes or a statement to be disclosed to the aggrieved or the person being disciplined, can you still take into account their evidence? This is quite a tricky one, to be honest, because as I say, it's balancing the right of the individual to have an opportunity to challenge the evidence and question the evidence, as opposed to your responsibility to conduct a full investigation. And I think you need to take into account why they're refusing. First of all, the witness, if they are your employee, has a duty of fidelity, a duty to act reasonably in the course of their employment. So that's the first point of call. You are asking them as an employee to provide you with a statement, and it's part of their employment, part of their responsibilities to respond to that reasonable request and to do so. If there are genuine reasons why they're refusing, and their evidence is such that it materially changes your view of what is happening, or it's so important that it is absolutely necessary to take it into account, then I think you can do, but you've got to bear in mind that that is going to have an issue. That is going to create a dispute with the individual concerned, and therefore you're going to have good reasons already. So you've got to have in your head your reasons, your justification for agreeing that witness's statement won't be disclosed, and for taking that evidence into account. If there's a way of summarising the evidence, so by saying, you know, we have been advised X, Y, and Z, then do so, just so the employee involved has an opportunity to comment on the evidence itself. And overall, I mean, while I say the investigation is the cornerstone, a tribunal, if it got to that stage, would be looking at you acted reasonably in all the circumstances. So taking into account, is it reasonable to still consider that statement? Now you have to if it materially impacts on the evidence. So I would say yes, but be very careful. Put some pressure on the witness initially, and then get as much out of that statement as they're happy for you to pass on to let the individual comment. Let's see. How is it best to deal with sickness and investigating some mental health issues? Well, you know what? As I said at the beginning, an investigation is important in a sickness management process, as it is in every other process. It's important to show that you have explained to the individual what your standards of sickness are, the impact of the absence on the workplace, on other colleagues. You've investigated the sickness in terms of getting occupational health or GP or consultants reports, and you've discussed them with the employee and giving them an opportunity to comment on all that evidence. I think the difficulty in handling any sickness management process where you're involved with mental health issues is that it's very difficult, even for GPs in some respects, to pin down what the mental health condition is and what the symptoms are and how those symptoms would impact on day-to-day activities, how they'd impact them in the working environment. I think what I would say is that you're not, as an investigator, obviously, unless you are running a medical practice, you're not medically trained. You're not their medical advisor. All you can do is look at the evidence that you do have. If you have, say you have an investigation, a disciplinary investigation, and just their conduct rings alarm bells, then don't ignore the alarm bells as part of your investigation. You try and approach them in the most sensitive way that you can and obtain medical evidence if you need to as you go along. I don't know if that answers your question. There's no straightforward answer. I think you have to look at it on a case-by-case basis, depending on what comes up. With the right to be forgotten, right to be correction. Oh, I think this one's for you, Charlotte.
Okay, yeah, I'll pick that one up. So the question is, with the right to be forgotten or right to correction, how should we handle requests to remove documents, for example, medical reports, from a capability investigation where the report may be unhelpful to an employee's case? So I kind of summarising that, so I guess that's an employee is aware that there is potentially some evidence within a file that in an investigation would be unhelpful to them. So therefore they'd make a right to erasure request or a right to well, I guess a right to erasure request to have it removed. A right to correction, just to address that point, is slightly different. So if someone has incorrect data about you on a file, you have the right to have that corrected and put right. Now, there might be a reason why you keep the old record and somehow you demonstrate that it has been corrected because you want that that logging of there having been an error in the past in case there's ever a complaint or anything about that in the future, especially if it's something that is upsetting the original error. And so you'd want to have that corrected. So obviously, if there is something that is wrong in the investigation evidence and someone wants that corrected, then that should be corrected. That's their right to do that. But you may log that has happened and the correction activity has taken place. Because they may not be happy that it was wrong to begin with. In terms of a right to be forgotten, so this is a kind of almost common law derived in EU law and became part of the GDPR, so right to erasure. It's not an absolute blanket. You can't just say, I need my data completely erased. There's always going to be exceptions, and a part of that is that balancing act. So it'd be on a case-by-case basis, but if that whatever is trying to be erased is really key to the investigation, it's something that you have good reason to be keeping on that file, then the right of erasure would probably not apply. You'd have to look at what exemptions are applying to that right, and obviously respond still to the individual very promptly and at least within a month, and it be explaining very clearly why you're not going to be erasing that data. But there is always reasons why you're not going to erase someone's data, and that's absolutely justified in many circumstances.
I think can I add there as well, from an employment law perspective, if I was supporting you on a sickness absence process or a capability investigation here, and there were medical reports there that the employee didn't like for whatever reason, that's the purpose of the investigation is to gather all the information, whether it goes for you or against you, and equally that applies whether it goes for or against the employee. And it's, as I say from the previous answer, it's unlikely that you're going to be in a position to when you read the report, to say, yes, this is wrong, this is inaccurate, this is unhelpful, I'm going to ignore it, because it's a medical opinion taken at the time that particular medical profession reviewed the file or had an appointment with the individual. And I'd say in that situation, if it came up from an employment perspective, I would say, fine, I understand you don't like this and you think that the situation has changed from here. Let's get a fresh medical report then to see what the current situation is. And in any sort of process, sickness management or capability process where health is a factor, you should be relying on up-to-date medical information. That doesn't mean to say you can't take into account what was previously said, but you should look at the balanced approach. I think the next question is yours as well, Charlotte.
Okay, yeah, so the next question is, can you legitimately rely on the ongoing investigation exemption to withhold investigation reports from a subject access request? This is always a difficult one when you've got a subject access request that comes in midway through an investigation. I mean, the first point of call is, of course, that an individual is entitled to their personal data, regardless of the reason that they're wanting to have that. So that's kind of got to be your first point of call, but then you need to apply the relevant exemptions, which are found under the Data Protection Act. So there is one about negotiations. So if you've kind of got, if you've got to a point where maybe you're going to make a settlement or something like that, and obviously you're talking about that individual, the emails are very much about them, or the conversations are the minutes, but by handing those over, you'd very much give away exactly what you're about to do in your next steps. Then that's kind of where you can start to apply exemptions. There's also going to be other exemptions around other people's personal data. It's not necessarily an exemption, but you have to be careful about disclosing one person's personal data if that causes you to breach someone else's personal data. So that's where we are there. I mean, it very much depends on what those investigation reports are, exactly what they're saying. Are they actually really got personal data in them? Because that could be quite wide-ranging amount of data. So it's going to be on a case-by-case basis as to how you apply your exemptions. And whenever you do apply exemptions, keep a log of them. It's quite a tedious task, but do really, and again, like I say, involve your authority's data protection team in this, because they're the ones with the expertise and are used to doing subject access requests and FOIs and all of that, so they know how to handle it. But logging when you choose not to disclose something, exactly why, because if that individual complains to the Information Commissioner's office and they come back, you can say, no, we definitely did think about it. It clearly followed a good process, and this is the reason why we decided not to disclose. And that's going to be really important for you.
Perfect. I think the next question is mine. In a small business with only one director manager, how would you deal with an investigation, disciplinary and appeal separately and fairly? Do you know what, this is a really difficult position, and all the case law, all ACAS code of practice and everything talks about the the three-stage process, where you have different people involved at each stage to make sure each stage is objective and independent. But the actual legislation says that do you have a fair reason for dismissal? If it's one of the potentially fair reasons, considering the size and administrative resources of your organisation, was it reasonable in all the circumstances to dismiss for that reason? And that's what the tribunal are tasked with, looking at the size of your organisation and your resources in deciding whether the process you chose to adopt is fair and reasonable in the circumstances, or is within a range of reasonable responses that you've got as an employer in handling such matters. There's no one right or wrong way. And so in that situation, I would be looking, you small business with only one director. It may be though that you have either a HR manager, or you outsource your HR to a HR consultancy, and in many respects they're the perfect people to start the investigation, because they are trained in HR processes and conducting objective processes, and so that would be a perfect way of having at least a two-stage process. if you're the main director or manager, you would want to be making the decision because you would be the person at a tribunal justifying the decision, and you've got to say why it was right for your business to make that decision. And for an appeal, you can either bring back in your HR person and join them, so have a panel, so you've tried to have a create objectivity, or you can bring in external consultants, or you can turn around and say, look, we don't have anybody else, but if you have any, if you want to raise an appeal, if you're unhappy about my decision, then let me know the reasons for it, and I will agree to review it completely on the basis of those points. And it's not ideal, but that is, in your type of in a small organisation, that's all you can really do. And you've just got to be able to justify it and try your best to offer a fair process. I've got another question, sickness impacting grievance scenario. I don't know what this directly means. I'm thinking it probably means that if you've got a grievance and someone goes off sick during the process and it delays the process, I think it's balancing, if that is the question, it's balancing ensuring that the person is well enough to attend individual meetings, but you don't have to have a fit note. So if you've got a fit note that says they're not well enough to work, you're not expecting someone to work, you're expecting someone to attend one meeting. So there's ways around it, but I think we'd probably need a bit more on that one to answer it properly. So if there is a live warning on file that should be noted in the investigation report sent to the chair of the disciplinary hearing, or should that only be disclosed after the chair has made his or her findings and before a disciplinary penalty is imposed? I don't think there is a right or wrong answer. I don't think there is a right or wrong answer to this, because ultimately when you're making a decision to, and we've moved on to the disciplinary stage, when you're making a decision at a disciplinary stage, you should be thinking about it in 3 stages. The first one, did the individual do whatever misconduct is alleged? So did they do it? Secondly, how serious is that? So is it just misconduct? Is it serious misconduct? Is it gross misconduct? And then thirdly, in all the circumstances that you are aware of, what is the appropriate sanction? And so whether the chair has that information at the beginning or the end, they can take it into account when determining what the appropriate sanction is. Now, one school of thought would be to say, well, if they have it at the beginning, it may mean that they prejudge their decision. We don't have that sort of rule in employment law that you have in criminal cases where they're not aware of similar facts. You've just got to decide it on those facts. In employment law, you're looking at the overall situation, and I think it's important for the chair to be aware when assessing an issue. If the individual has done something similar before, then that is going to impact on how serious it is this time, and whether the investigation was reasonable and thorough, and whether they're happy to make a decision on that. So I don't think it either way. I think you could justify emails to an internal legal department asking for advice exempt from disclosure. I think not, but I'm going to pass to Charlotte.
Yeah, I mean, again, it's a case by case basis exactly what those emails are. Obviously, there's legal professional privilege that can apply to legal advice. I'd ask depending on what the emails are, if anything like that were to come into the scope of a subject access request, ask your internal legal. It's going to depend on what the nature is as to whether they think legal professional privilege is going to apply to that or not. Yes. That one.
Oh, I think we've just got another one in. Yes. Unfortunately, because all the questions come through as anonymous, I'm not sure. I think the yes is probably in answer to the query about sickness and grievance. But if after this event, and bearing in mind we've been going for quite some time now, and I appreciate you're all so busy, if after the event, if the individual who has those specific queries, if it's an ongoing issue and you're concerned about, just drop us an email. Our email address, my email address was at the beginning, and I'm more than happy to talk over that specific issue with you again. I think that's all the queries that have come through. Thank you so much for the questions and for joining us today. If there's anything else that arises out of this, then please let us know. We're going to send through a feedback form. I appreciate it's likely that you'll put on there, Julie Bann needs some IT training to start webinars again. I'm waiting for it. But if there's anything else that comes out, please let us know, because we do want to know if there are any other courses that you think would be helpful, either that have come out of this or on any other issue. Then both Charlotte and I are more than happy to arrange something at a later date. Thank you very much for joining us, and I'm going to say goodbye now, and I'll pass you on to Charlotte just to say her farewells.
Thanks everyone, and thanks for the questions after the Q&A. It's good to see that people are engaged. Sometimes you do wonder on these webinars if you're just if anyone's tuned in or not. So it's really good to see. And yeah, like Julie said, if anyone's got any questions at all, then please do drop us an email, or if there's any other webinars that you would find to be useful, maybe on something like subject access requests, then very happy to organise that. Thank you.
Marvellous. Thank you.